Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Arthur Baker talks about contractor agreements that don't overcomplicate things. So, let's tear it down. Arthur Baker, welcome back to the Contract Teardown Show. How are you today, sir?
I'm fantastic, Mike. Thanks for having me back on the show.
I'm glad to have you back today because this is personally relevant, and we know it's all about me. We are talking about a consulting agreement. Let me share this with the folks at home. This is an agreement between a company called Roll Up Shutters and Shades, spelled WROL, which is super original, and the Parkview Group. What is this document before we dig into it, Arthur? When are we going to see this kind of thing?
Yeah, so thanks, Mike. We live in this consulting world nowadays, right? And there is no form or market consulting agreement. You don't really even know what that consultant's doing until you actually start taking a look at the agreement. But a lot of times when you're a business and engaging these consultants, it's on their form. You may think it's for a low dollar value or a low risk. And you're in this decision mindset of, how do I handle this? And I want to just cover some pro tips of whether you can make an informed decision and sign as is, whether you might push for some red lines or minor edits, or whether you want to push for your form or some other form. I think in a lot of these situations, people tend to forget that your relationship is a critical unwritten deal term, and they might over lawyer these documents, and then unsurprisingly, the service provider is not so fun to work with.
Yeah, it's so interesting because consultancy is like normal in big business, but to your point, we're in this world now where fairly local businesses are using consultants as a way to scale and grow and be competitive with larger businesses. So I'm a fan. My book, Lawyer Forward, talks about this for lawyers. Like, how do you use other providers in your law firm? So I think this is relevant and interesting for a lot of people, including me now that I have a consultancy. So let's dig into it. So this document, give us the background to it. You were talking about you don't want to over lawyer. So talk to us about the relationship between these two parties and some background principles that you use for filtering through a document like this.
Right. So first and most important, if some of the clients I work with, small, medium-sized businesses, as well as some larger companies, you really want to understand, so what is this consultant doing? What is the purpose for this engagement? And understanding what their current relationship is like. Is it positive and there are other transactions that they've worked on with them for varying sizes and deals and they're ongoing? Is it negative? They recently had a bad experience or they changed the deal terms and now it's the first time they're looking at the consulting agreement. Or is there no experience? They don't really have any relationship with them. All of that is relevant when you start getting an understanding of, well, what service are they supposed to provide? What's the current tenor of that relationship? Because if there's, as we look at this, the Parkview Group, it says that they have business expertise in the areas of marketing and finance. Well, we'll get into that later of what service they're really providing, but they might be providing all of these services for all of your other co-business colleagues and other associates and been doing a great job. So you have that relationship strength. Maybe they play golf at your country club. And there's a lot of social capital that you can trust in them, which can allow you to take a little bit more of a informed decision and risk in the document itself.
Yeah, it's interesting because you're talking about using contract as a proxy for trust. But if you already have a trust relationship in there and social levers for trust, like is the contract actually getting in the way of that trust relationship? But people do want to be, to your point about pro tips, people do want to go pro. They want to be more professional in their relationships. The big question is, does this do it? So let's start with number 4, which is the monies. It says that the company is going to pay the consultant for services for a non-refundable $500 retainer each month and then $200 per hour. What do you think about the way they're handling money? Is this very professional, the way they're doing this?
Right. So to start with a pro tip on that, it's a lot of littles can make a lot, right? And what our natural instinct, a lot of my clients, the first thing we do when they get the agreement is, well, they said it was going to be X dollars. They thumb through it, try and find where the cost provision is and see what it says and whether it's parallel. And this, on its face, a $500 retainer and $200 an hour, we don't really know if that's going to be a lot of money if we don't know how many hours of services they're going to be, right? So you take a look at this, and it's got $500 retainer on the first day of each month. Under Section 3, you see that there's a 12-month term. So the retainer alone, that's $6,000 for the year. You look at $200 an hour. Well, how many people are working at $200 an hour? It doesn't say. There's no key personnel. There's no limit of individuals. There's no limit on hours per week. So just thinking of one individual working 40 hours a week at $200 an hour, and let's say he gets 2 weeks off vacation, but he's a consistent consultant work with your company, that's $400,000 for the year. So when we look at this and on its face, might see a 200 or a 500 and think it's a small contract. $406,000, that's not necessarily chump change for a lot of people.
Right. And the whole, one of the main reasons that you're getting a consultant in the first place is you're trying to de-risk the hire, right? The acquisition of that talent. You're trying to de-risk it. So not being clear on the money does the opposite. The other thing you're trying to get out of a consultant versus an employee who you're paying for attention is specificity and deliverables. I'm looking at 2 under services, and I'm not seeing a lot of specificity. What do you think about the way they've drafted Section 2 here?
So 2 is one of the stereotypical consulting agreements I see, where you remember Office Space and the Bobs. The consultants come in and they're talking to Milton of, so what it is that you do here exactly. And it's a great movie. Love it. Watch it if you guys haven't. But I always have that in my head when I'm reviewing like the services schedule. And when I read this, I'm like, so what is it that you do here, Parkview Group? And it's a whole lot of maybe. If you look at the first sentence on the lead in, where it's the consultant services may include, but will not necessarily be limited to, that's a little backwards. They're trying to set up a statement of a non-exhaustive list of actions they'll do. But what I like to see when I'm getting a service provider is the consultant services will include A, B, C, and D, but aren't limited to those. That's a may that you may want to change if you were to revise this. And then even further, when talking about deliverables, there aren't any clearly defined deliverables. Like looking at Section 2.2, they have them developing marketing plans. Is that providing them? What's the understanding? And like we started earlier, of having a discussion with your client, understanding what the real deal is, a lot of times they'll get a big fancy proposal that has all of these detailed items and super sexy marketing positions and a 5-year growth chart and all of that jazz. That's why they're hiring this consultant. But you look at the actual agreement and it didn't actually make it from the proposal into this. So another pro tip you want to think of on these services is you don't want to assume that all of the deal points that you thought were agreed to made it into the contract.
Yeah, and I'm wondering, even if there were deliverables, as I look at this agreement, I'm not sure who gets what. I mean, presumably, you can't be a consultant without having a 4-part matrix. So I can imagine this person who works for this consultancy at some point walking into this shutters and blinds company to a whiteboard and writing a 4-part matrix that this person has worked on over the years. Well, does that 4-part matrix, that you created to teach this particular company, does that now belong to the company? Is that yours? Even if there were deliverables through this time, it's not clear to me who owns it. What do you think about the IP rights that are in this document, or not?
Heavy on the or not, right? So, a pro tip you want to think about is you want to make sure you own what you want to own. And when you look at this document, unsurprisingly, when it doesn't address specific deliverables, it doesn't also include any specific assignable IP rights or ownership of those deliverables. A lot of times when a service provider is creating deliverables, they're incorporating some of their existing IP or other items into them. So that's often a very heavily negotiated or detailed provision. So when I saw this agreement of just 3 pages, very simple, right? It's not problematic that it doesn't identify deliverables or IP ownership if there is truly no deliverable or IP at issue. So it's important to think when you're thinking of the services you're going to receive, being thoughtful about what aspects of this might actually contain a deliverable. Uh, and looking at this, it would be having a discussion with the client of what are these marketing plans? What are these corporate financing activities?
Yeah, you might create like a strategic plan for where this company could go over the course of a year. Well, if you own that, if you as the consultant own that, now you can go teach that same sort of strategic framework to another company. But if that belongs to the company that you just advised, that's a huge difference in terms of who has the long-term value. And so probably important if you're going to have a document like this to be clear about it. Well, number 3 on termination, I'm also thinking about if I've done a bunch of deliverables and I've done a bunch of work for you and it's on my hard drive and it's in our emails and it's on your whiteboard and it's in my head, this termination talks about, hey, at the end of 12 months, we're going to keep going, but you got to give 30 days notice. It's like the end of a lease or something. Give me 30 days notice.
Right.
But there's nothing in here about what termination actually looks like. Are you taking your box and going home, or what that? What do you think about ending a term on an agreement like this?
Yeah, so one example I think of a termination problem that everyone, for better or worse, could probably relate to or understand is thinking of being single, going on a first date with somebody, might not work out. You each choose not to see each other again. It's not a very difficult relationship to unravel. But if you compare that to a 10-year marriage, you own a house together, have a couple kids, maybe a boxer, a couple dogs, a boat, some debt. On a 30-day notice, that's not really something that's an easy, smooth transition. There's a reason why there's a whole family law attorney network and industry. And I think it's important when you're thinking of the consultant that you're hiring, is it a first date kind of situation or is this a marriage? And being mindful of, do I own all of the couch and materials in the house since my name? Or did we go to IKEA together and we split it? And this is going to get real confusing.
Yeah, I'm thinking about, like, to your point on that, the scale of the legalization of, how much law stuff you're bringing into a relationship. Sometimes you see contracts like this. My wife and I, our first date was we went to Taco Bell, and it's almost like people are creating I know it's super romantic. People are creating a document to say who gets to have the wrapper from the burrito when it's just like, man, we just went on a quick date. And to your point with this is like a long-term, there's a lot of advice being given. But
right.
I want to be mindful of what people are trying to do here. And I'm going to read between the lines here and ask you what to do about this. I'm looking at this as this is probably a couple buddies in a town and they know each other, like you said, from the golf course. They hang out and they want to formalize a little bit this relationship where, Joe is just like giving advice to Sam over here over golf. And now they want to formalize it and create some kind of structure. How do you, if you want to be a consultant, being a consultant is like by nature wavy, it's a lot of it is unpredictable. How do you use contract to build in the flexibility that you want, but also the protection that you want? Is that a longer contract? Is that a shorter contract? Is that no contract? Is that just two guys shaking hands? Two people, a man and a woman at a restaurant who like each other, shaking hands and saying, let's talk about this later. How do you maintain both flexibility and protection?
Right. So before I opened my law office, I worked in-house for a large global real estate services company where, unsurprisingly, our primary revenue generator was services. So we were the service provider or consultant. And I also negotiated a variety of consultant agreements where we were the recipient of services. One, I even negotiated a magician services agreement, magical experience.
But I see what you did there. That was
I try to get all these bumps, yeah. And it's important to just think through the practical realities of when the relationship separates, who's more likely to have more stuff or actions outstanding. And typically the service providers just want their money. And if there's an outstanding payment framework, is it clear and expressed that all amounts payable to that date are still to be paid? But more often it's usually the company receiving the services that they want to have a finished deliverable. They want the intellectual property to be formally assigned and finalized. So it's always important to think of which position are you thinking from, And then also just what's the nature of the services in the relationship. So in the overall with this agreement, if this truly was meeting at the golf course, they know that one of the contacts at Parkview Group has worked with a bunch of the other people at the country club. I would look at this agreement and feel a little unsure with some of the vagary of the services, but it's talking through with the client to understand what is it you're really getting. Did you clarify? And if there weren't any deliverables, I feel comfortable there's a back-end termination. And if you have a relationship where he's probably not going to try to ramp up, 20 or 10 individuals putting in 40 hours a week for 1 week, I mean, that alone could be 80 grand in a week with no right to dispute that bill. But again, trying to not overload a situation to where the services are now not going to be great, the relationship's tenant. I think this is an agreement where it might just reflect that country club handshake, and it's about having that informed decision of that you went forward knowing these risks, or that if you brought them up with the Parkview Group, this consultant, that you're actually on the same page. Because sometimes they might say, oh, you didn't actually pay for that fancy 5-year plan. That's an extra 20 grand.
Right. Yeah. And I can say, as I mentioned earlier, this is relevant to my business and to what I'm dealing with. And for what it's worth, I am sort of at the point where I'm combining this with a conversation I had in another episode with John Grant and an agile contract, and a bit of a hybrid arrangement where the consulting stuff that you want to be flexible, you want to have the ability to pivot, both in terms of your advice and in terms of what your deliverables are, have that in the contract that there's, agile, there's flexibility. So I would encourage you guys to go and listen or watch that episode. But also, for the sake of the buyer, the person who is buying the services, they do want deliverables. So use that as an opportunity to have this sort of hybrid arrangement where you can get detailed in this way. So that, for what it's worth, that's my solution, is trying to build in both, because I think it's important. I think to your point about going pro and these companies that are probably historically have built on handshakes on a golf course, it's time to go pro. It's time to improve your processes, including sort of the legal relationship. So I appreciate you sharing that, Arthur. For people who want to learn more about your practice and get in touch with you in Florida, what's the best way to do that?
Yeah, best way is probably by email or LinkedIn. It's Arthur Baker. My office is Concord Advantage Legal, based here in Tampa, Florida. You could email me at abaker@concordadvantagelegal.com. And better yet, just add me on LinkedIn. That's how we connected originally. So Arthur Baker, Concord Advantage Legal, and always happy to chat.
Perfect. We'll make sure that's available at the episode information over at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show, just email us. We are at community@lawinsider.com. We will see you all next time. Thanks again, Arthur. Have a great day.
Thanks so much. Take care.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.